Thanks for staying with News Central. We shift our attention now to Uganda's new legislation allowing military trials of civilians. It was signed into law by President Yoweri Museveni just on Monday, June 16. This is a move that opposition leaders says violates an earlier Supreme Court ruling and undermines the country's judicial independence as well as human rights. Rights campaigners have also tagged along. They have alleged that the government has used military courts to prosecute political opponents of Museveni, who has been in power for almost 40 years. His aides have denied all of this, saying only civilians who use guns for political violence are prosecuted in such tribunals. Well, that's the conversation we want to have with someone who understands what's happening in Uganda. Samuel Wanda, he is the managing partner, Matsiko, Wanda Arinda Advocates, Kampala, Uganda. Thank you so much for sparing the time to speak with us. Talk to us about the circumstances under which civilians can be tried in military court according to the new law, and if this is actually strictly adhered to.
Thank you so much. Good evening to our viewers. It's absurd that what we try to fight from 2005, when the UPDF Act was enacted, we only got some relief by the highest court in the land on the 31st of January this very year. By the turn of events, twist of events by the executive, we now have back the same law which tries civilians in military courts. The law is quite vague on our side, because we believe, as per the Supreme Court, no one should be tried in the military courts as long as they are civilians. But the state has tried to create scenarios under which they can try civilians in those military tribunals. And among the scenarios is one if you're aiding and abetting a service offense and a serving officer, but also they have created particular offenses that can be tried by the military courts, and among them is cattle rustling, they have murder, which we believe these are offenses that should be tried by the ordinary courts. In the ruling which we got from the Supreme Court, it only created that civilians or even military men can only be tried for criminal offenses in exceptional circumstances, and where there has been a demonstration, that the civil courts cannot ably handle such a matter. But this is not what the law has tried to cure. The law has actually they have introduced the one exceptional circumstances in the law, and now they have created what they believe is exceptional circumstances, which we believe is against the spirit of the Supreme Court judgment that was delivered this year.
I'd like for us, as quickly as you can, as extensively, what this law prescribes and why the people are against it, using a Supreme Court's ruling from just January.
Yeah, the people are against this particular law because it's not in good faith. It's intended to curtail the opposition politicians from freely expressing themselves and from freely participating in the political field of our country. When you look at the law, the manner in which it was passed, there was a lot of rush in it. We had the law being tabled, and within a week, it was being passed by Parliament. We recently, I think yesterday but one, we saw the Speaker of Parliament, where she was campaigning for one of the positions in the ruling party's SEC, which is the Central Executive Committee, which is the top organ of the party, which was campaigning, said she only has two people she fears, and that's her God, and then the president. And also that that's why whenever anything the president wants will have to pass. Now we believe that the Parliament did not really passed this particular law as one of its roles of legislating, but was trying to appease the executive and the president to try and pass something that we all believe is not intended for the common good of the Ugandan, but rather to frustrate and curtail people's freedoms and them participating in our normal politics. You will look that among the directives that were given by the Supreme Court was the transfer of all files to civilian courts. And the issue of exceptional circumstances was, by the way, it wasn't in the main ruling. It was kind of guidance after the judgment had been read from the Chief Justice. It is shocking that the state has vested all the energy in trying to bring into place the advice and guidance that the Supreme Court judges gave, rather than putting all energies in ensuring that the judgment of the Supreme Court is being implemented. That shows you the intention and ill will on the part of the state. And that's why the law is categorically being fought by all well-meaning Ugandans, all people who believe that we should have a free and fair society, a democratic society. When you look at this particular law, it's giving the commander of the defense forces too much powers.
Okay, in actuality, what can citizens who oppose this bill, aside from voicing their displeasure, what can they do to have the law changed, repealed, or just, modified if that's what they want?
As we speak today, because under our laws, you cannot challenge a law unless the president has assented to it. So we saw copies being assented to yesterday in social media and mainstream media, and I can confirm without any fear of contradiction that several human rights defenders, several human rights lawyers, and the team from the Ugandan Society already putting their brains together. We already had a draft. We now just have to finalize it and ensure that we can file the same as soon as possible. Our Supreme Court and the Constitutional Court already have precedents to the effect that Parliament cannot legislate to outlaw a court judgment, and that is under Article 92 of our Constitution. And this particular legislation shows that indeed they legislated to outlaw a Supreme Court judgment. But also, our Constitutional Court and the Supreme Court have also been very instrumental in delivering judgments where the rules of procedure have been faulted. One of the rules we believe was faulted was participation of the stakeholders, participation of the public in this particular legislation. If you may have followed the procedures, for the first time we received notices from the Clerk of Parliament to the stakeholders. You receive a notice in the morning and they are calling you for a meeting at 9 a.m.
Okay.
And the letter is dated that very
we're time pressed, but there are some questions I want to see if I could get some response from you. One of them is the judicial independence. Where do you stand on how independent the judiciary is in Uganda and how laws like this might or might not impact its relevance?
We have a challenge with the judiciary, but as a lawyer, my role is to defend the Constitution, to defend the judiciary, and any other arm of government, and we shall put them to test with this particular law. There are instances where they have been confident and they have stood their ground, and they have given to Ugandans to what they really should get. There are instances where the judiciary has stood its ground and defended the Constitution. So all hope is not lost. We know that some judicial officers are not independent. Some of them act on the whims of the executive, but we still know that there are those judicial officers who stand their ground, and we are very sure that when we present a petition to them, they will definitely nullify that particular law. Why we say this is because prior to the 31st of January judgment, we had about 5 Constitutional Court judgments and nullifying that particular provision of the UPDF Act. So this won't be new to them, and we shall use the very precedents of the Constitutional Court and the Supreme Court decision to try and show the unconstitutionality of the new provisions that they have brought into the UPDF Act to ensure that the same is nullified.
Are there any further potential risks or unintended consequences of this law that has not been widely discussed that you would like to highlight in the little time left?
The intended risk to us is majorly to the human rights lawyers, to the human rights defenders, and to the politicians. The intended risk of this particular law is the abuse by the implementers, and that is majorly the military. We've had this argument before on who determines which murder case should go to the military courts, who determines which cattle rustling case should go to the military courts. And that's why the Supreme Court said that it should only be in exceptional circumstances. And what it meant by that is that if the state believes that this particular case should be tried in the military court, they would file an application in the civil courts, make their arguments for that, and then if the civil courts are satisfied that indeed this warrants trial in the military court, then they'll give that effect. But it will be an open blanket where anyone they arrest, they can determine where to charge them. And that's the abuse of the law that we are looking at, and that's the biggest risk that we see coming forward.
Samuel, thank you very much for speaking with us. We appreciate your time.
Yeah,